If it pleases the court, counsel. Good morning, Your Honors. My name is Joe Bodiford. I represent appellant Rogelio Perez. He's currently in state prison doing 25-year minimum mandatory sentence as a result of this case. His mother, father, and sister have come from Ocala to join us today. This is an appeal, and this matter is before Your Honors on the denial of a motion to suppress a search incident to a search warrant. And I believe that our argument could be summarized as, if you don't hear the tone, leave the house alone. That's what it boils down to. And so looking at this matter and looking at how this case is unfolded, at the end of the day, we're left with one undeniable fact, which is that the clear, concise, narrowly drawn language of the affidavit and the warrant required the tone to occur before the search happened.
And let's talk about that, Mr. Bodiford, because I think that's what you're hanging basically your entire argument on. When the affidavit was put together, I mean, basically this is an anticipatory, search warrant. And the state argues that you're saying that that had to be the triggering effect. Can't you read the affidavit say that this will assist us? Because the whole scenario is, and let's put it in perspective, they have evidence, or they know this has been an ongoing investigation, that these are drugs that are being mailed from New York to here.
Clearly.
They were able to stop one package, the postmaster, and opened it up, and sure enough, it confirmed the presence of drugs. So when this package, they anticipate there's going to be another package coming in. They went and put a warrant together, asked the court to sign off, and the language of that warrant said, here's what we anticipate, that this package will be mailed. What we want to do, we want to make sure that you'll give us permission to intercept that package in order, because we suspect that drugs are there. And wasn't there language in that warrant that said that this will assist us? So it's not like the beep, what they said, that we're planning to wire the package so we know when the person opens the package, that will alert us, and that way we could go in and retrieve the drugs to make sure it doesn't go somewhere else.
Right.
So,
and meanwhile, and they're chasing him all over Pinellas County at the same time. All of those things are absolutely accurate.
Okay, so why is it you're taking the position that somehow, because the beep didn't go off, apparently maybe it was in a tin can, so I don't know whether it was shorted or not, that by itself negates this whole thing?
2 words.
Okay.
2 words. So that. So that. And if you look at page 8 of the affidavit, the third full paragraph down, law enforcement clearly clearly drafted this language to say, and following upon, it's page 8 of the search warrant, and in the record that would be record page 345 of the record.
Okay.
I pulled the actual, I was trial counsel over in Pinellas, so, and I've seen the 10, and I'm very familiar with all these. But here's the critical language, and this is why the state doesn't get to follow DiPolito's, it was just a tool thing. And this is what is written on page 8, third full paragraph, 1, 2, 3, 4, 5, 6 line down. It will assist law enforcement in knowing when the parcel has been opened so that execution of the search warrant may occur. So that. And that's where they hang themselves. That's what, and it's clear when you read it this way, that was the whole idea. We're going to hear the tone, we can go in. And that's why DiPolito waited. And if you read the testimony he gave at the suppression hearing, he can color it and try to cobble together whatever argument he wants. He waited because he knew he had to hear that tone.
Well, let me ask
and
you
that's
this.
so that.
Okay,
so
well,
that.
how about this? Let's push all of this aside.
Okay.
How about the following facts? And this is what the facts that were presented. That when the knock on the door was made, Mr. Perez opened the door, and then he was asked, "Are you Mr. the fictitious name?" And he acknowledged, "Yes, that's me." And then he made a statement saying, "Oh, I was waiting for this, it's late."
Right.
Okay. Then signed his name with the fictitious name.
Right.
So regardless of whether the warrant was here or not, the beep, whatever, isn't that by itself sufficient? Given the fact that there was that, they knew all the prior investigation. Did that give enough cause to go in and to retrieve the package?
The answer would be, well, as any good law school answer, as we teach our students, would be, it depends, right? I like yes, but. Yes, but had they left so that execution may occur, had they left that out of this, we wouldn't be here. They wrote it. And the case law we've got from the Ninth Circuit and from Supreme Court of Alabama and all those places that talk about narrow and concisely drawn language, that's it. They wanted this condition. Law enforcement made this, and Judge Downey signed off on it. So had they left this out with everything else, and Judge, we're really, and this is where I think the state's brief and the state's going to go with, we're not arguing probable cause per se for issuance. We're arguing it was illegally executed.
Okay, since you're referring to the warrant, let's look at the very last sentence of that warrant that says, your affiant, Detective DiPolito, requests court authorization to place and monitor an electronic device that will transmit from the inside when the express mail parcel is opened and distributed. And if you look back up, it's mainly to assist. So you're reading, I think you're reading it awfully narrow, Mr. Bodiford.
And I think we have to, Judge, because I think not to goes against what all the cases of Isikuru, Ricciardelli, Moran, Gautier, all those other cases tell us. If that's the way it's written, then that's what we have to follow. And Judge, by analogy, if law enforcement is got a string of hotel rooms and they're watching them, and they see a defendant going out of room 1, room 2, room 3, room 4, and they see all the visitors coming, and the CI's telling them this guy's got girls in every room, he's dealing, he's got drugs in every room, he's having a big party, and they can go get a search warrant for room 1, and they go into room 2, sorry, it wasn't for room 2. It's how it's written is how it has to be interpreted, how it has to be executed.
But that's a different scenario. And I think in this one, you have to look at the whole warrant, the whole thing.
Yes, Judge, as far as probable cause, yes,
okay.
Absolutely. But and this is where Judge Federico hung his hat. He says, well, yeah, I think there was enough, which is what DiPolito said that day. I waited, but there's enough. And that's the problem with the way they wrote the warrant. When the triggering event on this conditional anticipatory search warrant, the triggering event was not only the tone, but as they say, when the parcel is opened and its contents received. So they wrote it not to just be the delivery, which is what the state's going to say is the triggering event, the delivery. No, they wrote it to say beeper so that it can be executed and we'll know that the package is open and its contents received. And that's why I am reading it that narrowly.
Let me ask you this question. Reading Grubb, there's at least 2 conditions precedent. I'd like to focus on the second one, which says the second prerequisite of probability is that there is probable cause to believe that the triggering event will actually occur. I note it doesn't say that the triggering event will occur, but only probable cause, reason to believe that, in this case, the beeper will go off.
Yes.
If I understand your argument, it's that the law says you only have to have probability or reasonable belief that's going to go off, but because they put in the warrant that this, so what, they've raised themselves to a new legal standard that Grubb doesn't require. Because Grubb seems to only require that there's probable cause to believe the triggering event will occur. If the triggering event is the beeper going off, it's probable cause to believe the beeper is going to go off. But Grubb doesn't say it has to go off.
But again, that's for issuance of the warrant. We're not saying that Judge Downey didn't have probable cause to issue.
Well, if the law only requires that you have probable cause to believe that this device will go off, and it doesn't go off, does that then invalidate the warrant says you can't execute it now?
Yes, I think it does. And here's why. If you look at the language in Visikuru from the Ninth Circuit, they actually ruled against him, but a very thoughtful assessment of this area of law. One of the things they talked about was that the purpose of strictly defining and clearly defining these triggering events restricts the officer's discretion once they're out there on the street in the thick of things. In the Moran case from Alabama, same thing. It's to prevent premature execution and governmental abuse. That's why I'm so adamant about this particular issues, because, yeah, we can see the probable cause for the issuance, but once that narrowly defined triggering event is so defined, Law enforcement takes it on the street, that's when these things can get gray. And had they not put this in there, we wouldn't be here, but they did. They did say, so that execution occurred when we know that the package has been received. Not artfully drafted by any stretch of the imagination, but yet the state attorney's office of Pinellas County signed off on it. They went to Judge Downey, he signed off on it. We're left with what we're left with. So I'm not saying that the PC standard in Grubbs is heightened. I'm just saying that the ministerial duties have to be defined, and they were abused.
In the Davis opinion the Supreme Court put out in 2011, there's some language in there that I'm concerned about. It says that under our exclusionary rule precedents, police practices trigger the harsh sanction of exclusion only when they are deliberate enough to yield meaningful deterrence and culpable enough to be worth the price to be paid by the justice system. And I realize that wasn't argued, but I happened to be reading Davis for another case, and I thought about this one. Historically, it's been the jurisprudence of our country. We want police officers to go get a warrant. We don't want them to do it themselves. So they go get a warrant, they have one that arguably meets the requirements. If Davis's language applies, what's the deterrent effect in here that is so culpable that would require us to exclude? And again, I'm not sure that Davis does apply, but that language, when they're talking about precedent, and they have been restricting the application of exclusionary rules since Chief Justice Rehnquist was on the court, and maybe even before then, but I know historically, that is sending us a message, at least the way I read that, be careful before you exclude if the police officers haven't done anything that's culpably wrong. How do you view that?
I would balance that against what the Ninth Circuit said and what the other courts have said about.
Rumor has it the Ninth Circuit doesn't do too good with the U.S. Supreme Court in history, but leave that aside.
That might be why I'm calling the Ninth Circuit for opinions, Your Honor. But you have to weigh it against, and I understand exactly what you're saying and what Davis said. Is it something bad enough that we say you can't use it? We essentially punish law enforcement, for lack of a better term, or slap them on the hand. But when you look at what the cases I've cited talk about as far as the whole purpose of having a clearly defined triggering event is to reduce their function to nothing more than ministerial. In this case, do you hear a tone or do you not hear a tone?
And reduce their discretion.
I'm sorry?
To reduce their discretion.
To reduce their discretion. And then when they violate that, I'm sorry, you can't use the evidence. And that could apply to, Your Honor, you could extend it to maybe my weak analogy about the hotel room. Well, we told you could search one, you search two. You can't do that. We told you to go and get it. What about the staleness issue? It's the same thing. We will, you can't sit on a search warrant for 45 or 60 days and then go execute it. You have to do it then, and they get punished for abusing that discretion. It's the same thing.
Mr. Barr, and I guess the thing where perhaps I don't see this, if you're taking the position that this was a clearly defined triggering event, and if that's the case, you'd be correct, but I don't see it that way. I don't see the warrant as drafted to be that narrow. I think what happened in this case, if you look at the whole process, and if you look at what has been presented to Judge Downey, here's the history, here's what it is, give us permit, we're gonna do this just to make sure that whoever opens the box, we wanna make sure that it's that, they don't want this thing, like you said earlier, to be lost somewhere else, and that's pretty dangerous.
Tens of thousands of dollars in investigative costs, clearly. But had they applied for a search warrant for his car and instead searched the house, they don't get it. No matter how much money they spent, no matter how many man hours they spent chasing him all over Pinellas County, if he violates the black and white letter of the warrant, the triggering event, or whatever conditions the court puts in the warrant, they don't get it. So that's why I don't want the court to fall, I don't want to say fall in the same trap, but go down the same path as Judge Federico and look at that. Because at the end of the day, that's a probable cause issue. Warrant was fine. It's not like we had a bad CI or bad information or illegally obtained information from somewhere else and we're attacking the PC. No. The PC was okay. It was the illegal execution. And all of that can't save that.
How about this scenario? Let's just assume there was no warrant at all. They're watching Mr. Perez, and then the same exact facts occur, where statements from Mr. Perez signing off on a fictitious name acknowledging that, and I think the most damning, quite frankly, testimony here, he brought it to himself. He said, I've been waiting for this. It's late. And then he signs off on that without a warrant. Is that sufficient for the detective to proceed?
Well, if it's to proceed to kick down the door, no. If it's proceed to seal off the house and go get a warrant saying this is now everything that we've seen, and he just accepted it, they're going to get another warrant. And if there's no particularized triggering event that has to occur on a anticipatory search warrant, and as the case law says, they're all anticipatory in some nature because you're of the anticipation you'll find something.
That's true.
They can't kick the door in that scenario. They could seal off the house and hope it doesn't get flushed down the toilet by the time they get back from the courthouse with the warrant. And if they write the warrant correctly and they put in there everything that's happened, and say they leave out the tone thing, they just say we delivered it to the guy, then they've got good PC. How they execute it when they get there may be a whole different thing. And that's, again, where I really want this court. I hope that you all will focus on the execution and not necessarily the broad reading of the probable cause, which, granted, you're right. This was a huge deal, but it doesn't save it.
I don't know if you were going to reserve any time.
Yes, I was going to reserve 5, so thank you very much.
Thank you, Mr. Bond.
May it please the court, good morning. My name is Donna Koh. I'm here today on behalf of the state of Florida. What we learned from reading United States versus Scruggs, which this court is accepted and adopted in Chen, is that there is no particularity requirement regarding a triggering condition. The only particularity requirement in a search warrant is that it must be specific as the place to be searched and the person or things which need to be seized. And of course, both of those were contained in the affidavit and search warrant. However, as Judge Casanueva pointed out, when you are looking at the situation of an anticipatory search warrant, there needs to be 2 requirements met that you read that have to be gleaned from the affidavit. One, that if the triggering condition occurs, there's a reasonable probability that the contraband is going to be found in the place to be searched. And secondly, there is a probable cause to believe that the triggering condition will occur. Now, 2 things I'd like to say about that. You also must read the affidavit in its entirety to see if both of those requirements have been met. So consequently, a hyper-technical view of one sentence contained within the affidavit is really insufficient. You look at the entire affidavit, and that's what both the issuing judge here did, and then of course the reviewing court. In the affidavit, the 8-page long affidavit detailed all the facts that Your Honor has already recognized. And consequently, there was indeed sufficient probable cause for not only issuance of the search warrant, but then to have the search underway once the officers who were observing the controlled delivery, it was a controlled delivery in this case, of an express mail parcel, meaning it had to be signed for, so there really isn't a problem with a slippery slope argument of leaving drugs on the front porch and running away. Someone had to come to the door. And probably, or I'm speculating that is one of the reasons why the police officers wanted to put this alert into the package, because their investigation showed that there was maybe 2 or 3 people that were possibly going to be in that house and would take ownership of those drugs. But in this case, so very fortunate for the police officers, Mr. Perez is the individual who came to the door, and they all knew, their surveilling police officers, the postmen who they'd set up for the controlled delivery, they all knew what Mr. Perez looked like. So they were able to know right away that Mr. Perez had not only opened the door and made the incriminating statements, but he accepted delivery of the known heroin and took it into his home. So at that point, what we have, and it's really expressed enough in the affidavit to cover it, of course, we have delivery of a known parcel of heroin to Mr. Perez, and then it was taken into the home. One of the ways, and I was considering this when I was preparing for our oral argument, one of the ways that you can look at the alert, it was actually a condition subsequent. And the reason is because the probable cause for the search of the home and execution of the warrant had already taken place. You had delivery of a known parcel of heroin to Mr. Perez, who then accepted it and took it into his home. So probable cause for the search existed at that point in time. The search warrant could be executed. The alert was an A. It was something else. It would have just helped the police know that indeed the parcel had been opened, which wasn't significant to the determination of probable cause for the search.
What if the package had just simply been opened on the front porch in full view of everyone?
By Mr.
But the electronic alert didn't go off by Mr. Perez?
By Mr. Perez, he would, yes.
I mean, would we be here?
No, probably not, because
I mean, to me, it
it's
looks
right
like
in
it's
front of
a
the
tool
police.
to assist law enforcement to know when the package is open.
Truly.
There are other ways to perhaps learn of the opening of the package.
Yes, yes, absolutely. And it's not significant to whether or not
It doesn't really have anything to do with the merits. This is
doesn't.
probably more directed to Mr. Bodiford, but he can think it over while you're up here.
It's true. It was just an additional tool by the police officers to let them know. And when you really look at that second condition, the second requirement, it says that there's probable cause to believe the triggering condition will occur. How can the electronic alert ever fulfill that second condition? It couldn't be a triggering condition. It was the one thing in the entire operation that was outside the control of the police officers. They couldn't control if there would be a short or it wouldn't work, but they controlled everything else in this case. This case actually is even a step better than Chen, because in Chen, the affidavit there was no triggering condition in either the affidavit or the search warrant, but this court read it in because of Grubbs. And I want to quickly point out that many of the cases that are cited in the initial brief are pre-Grubbs. And Grubbs was pretty clear about there being no particularity requirement regarding a triggering condition. So if this court doesn't have additional questions, I will ask this court to affirm.
Thank you.
I'm hesitant to come back up, knowing that Judge Black's going to ask me the same question.
Does that undercut your argument? If Mr. Perez had opened the package on the front porch and the police officers saw him open it, do they still have to wait for the electronic signal?
I would answer that it's a different issue, so I can't say it undercuts my issue, but I would say it's much akin to the facts they had in the Visikuru case, where the package was left on the porch and then disappeared, and that the triggering condition was that the package be taken into the house.
How does Visikura help us if it was issued in 2002 and Grubbs was issued in 2006?
Well, I don't think Grubbs in any way abdicates or reverses or...
I guess I should say, Visikura is not a Grubbs analysis though, right? Because Grubbs came out subsequent.
Right, but Grubbs again is PC for issuance, not
PC.
What do we do when the execution, when there's something wrong with the execution. And again, everything Ms. Koch said, and this is a case she and I have discussed many times over the months coming to this day, this isn't an issuance situation. It is an execution situation.
It seems to me that you're reading into the warrant something along the lines of, if and only if this electronic device is triggered, is this warrant valid? And if the electronic device is not triggered, that will negate the validity of this warrant.
If you don't
That's
hear
the way
the
you're
tone,
reading it?
leave the house alone. That's the argument, Judge. And it's not the way I wrote the warrant, it's the way they wrote the warrant. And again, looking at that page 8 of their affidavit, it's so that we will know that the package is open and contents received, then we can execute the warrant. That was not the delivery, the reopening of it, the receipt of it. So,
And you're discounting, Mr. Brown, all the other language in the warrant regarding that this will assist law enforcement. It just, I guess I'm still I'm troubled by the narrowing reading of the way that you are proposing.
the assistance, it's like DiPolito in his argument at the suppression hearing, how it's a tool. Then why put it in there? If you can stop with, and we deliver it to the house, and once we see him take it.
Have you seen you've seen your fair share of a whole bunch of search warrants. There's a lot of language in there that all three of us have signed off on.
Sure.
And a lot of language that perhaps, do they really need to put it in? But people put it in. But do you zero in this very narrow interpretation
I
of
think
it?
because, again, it's not the history of the case, it's not, is there probable cause for me, circuit court judge, to sign off? It's, once I sign it and you take it on the street, what's gonna happen then? And are we going to uphold the way you served it, or are we gonna punish you, like Davis said, and say, you blew it? You overstepped what we said you could do. And so, yes, I think we have to read it for the sake of law enforcement, for the sake of the people. We have to read it that narrow, because when the order of a court is written in a certain manner and they step over it, then if we move the line back for this one, where does it get moved the next time for law enforcement? So that's why I'm taking that position, and I think it does have to be read that narrow. So,
Well, I guess the concern I have is, who sets the line that we have to draw in the sand? The non-legally trained police officer who drafts a warrant, or the Supreme Court of the United States that issues an opinion and says this is the law? I mean, the police officer just writes an affidavit. They're not trained and schooled, and it may pass it, and it's not necessarily, that's a wonderful run-on sentence to your affiant certifies and goes on forever. But the Supreme Court has said for this warrant to be valid and to be validly executed, you need to meet these two prerequisites. And that's my concern, because it doesn't say that the triggering has to go off in order for it to be validly executed. For the warrant to be valid, it has to have probable cause to believe it will go off, which is even a step removed. So there's no guarantee with technology these days, I guess, and for me that's true because I don't like technology. But anyway, that's my concern. Is the warrant, the device, is your argument that the warrant sets forth the legal standard to follow, rather than, in other words, if the police want to circumscribe or reduce their area of zone of operations, they can do so?
Clearly, absolutely they can, Judge, because if you look at it like this, Judge Castaneda, the issue is how they wrote it, and looking now, like the case law says, just step back and take a plain reading of this. What did they intend? They didn't intend for it to be a tool. They said, when we hear the beep, then we'll go in. And that, again, is why DiPolito waited, because he knew he had to have that tone.
Well, what they said was your affiant certifies that through the use of said electronic signaling device, comma, information will likely be obtained concerning this ongoing criminal investigation, comma, in that it will assist law enforcement in knowing when the parcel has been opened, so that execution of the warrant may occur, and will assist in identifying those individuals inside the residence who have knowledge of the parcel's contents. If I wrote this in an elementary school, the nuns would have slapped my hands.
Yeah, agreed. It's the so that.
But there's so much in there, it will assist in information. It's like it's adding a piece to the proverbial pie.
Yeah, but I think if you took the nuns or the lay people out there and gave them this and said, what is law enforcement intending? They were intending to hear that signal. That was their triggering event.
How about, Mr. Buffer, it said may. Shouldn't your argument be strong if it was shall? If you're going to read it that narrowly, the fact that it said may, that gives...
Well, think about that, Your Honor, as far as if something else when they're out there and they're doing this on the fly and they've got their warrant, they're holding it, and something goes wrong, they may not want to pull the trigger on the search warrant right then for investigative reasons. So, maybe that was, again, another, not but another very purposely and carefully chosen word by law enforcement. So I don't think any of this stuff they do haphazardly, and I think the record reflects it was given to the state attorney's office beforehand. So I ask that you reverse remand with directions to grant motion suppress. I've moved to Tallahassee. I don't know if you all know that, so I probably won't be seeing you all again for my hometown. Won't be seeing you along for a while, but it was good seeing you all.
Mr. Buff, you all do such a great job. Thank you,
Your
sir.
Honor. Thank you, Your Honor.
Good job.
Appreciate
Thank you.
it.
Thank you
Good to
both.
see you.
Thank you.
much to think about. We will take a brief pause. We have one case remaining on our docket today, and we'll come back. What was that old adage about 10 rested and ready for that one?
Okay, all right, thank you.